Joe, tell her that.
There are a lot of refreshments, so if you want to take something back to your seat, do it now. But we'll have a chance to have some more later, too. Welcome, everyone. Thank you for coming to the League of Women Voters, Leelanau County's fundraiser on this blustery evening. I'm Vina Meixel, and I'm president of the League of Women Voters, Leelanau County. We appreciate your support of our newly independent league, and I'm confident that you're in for an outstanding presentation by Justice Kelly tonight. Before I continue the rest of my remarks, however, I'd like to ask that we observe a moment of silence for a dear friend and a league member, Eileen Walcott, who passed away earlier this morning after a valiant fight with cancer. Most of you know about the League of Women Voters. The National League has been around for almost 100 years, and the League of Women Voters was created just after women got the right to vote. Our group became official this past summer when the national and state leagues recognized our group. We number more than 90 men and women. Yes, we do have male members. That requirement was changed in the 1980s. Would the people here who are league members please stand? Thank you. To find out more about us, there are brochures by the door, and we welcome you to come to any of our monthly meetings. They're held the first Wednesday of each month in the Government Center at noon. The League is a nonpartisan group. It's political, but the League never, ever supports parties or candidates. We do encourage the active and informed participation of citizens in government, and we study issues at the state, local, and national levels, and we advocate and educate about the positions we take. The League believes that every citizen's right to vote should be protected. We believe that all levels of government should be transparent, and that financial records should be accessible to the public. Justice Kelly's work complements these league goals. Justice Marilyn Kelly was a courtroom attorney for 17 years in Michigan before being elected in 1988 to the Michigan Court of Appeals, where she served for 8 years. In 1996, she was elected to the Michigan Supreme Court for her first 8-year term. In 2004, she was re-elected, and in 2009 through 2011, she was the Chief Justice of the Michigan Supreme Court. Her many accomplishments and honors could take me hours to relate, so I won't do that. After retiring from the bench, Justice Kelly and James Ryan, Senior Circuit Judge of the U.S. Court of Appeals for the 6th Circuit, agreed to chair the Michigan Judicial Selection Task Force. Its mission was, quote, to assemble a group of persons of superior character, integrity, and intellect to study the processes of judicial selection in this state and various alternatives that are exercised in other states. The study was to affirm what is good about Michigan's judicial selection processes and to formulate recommendations for appropriate changes that could enhance or elevate public trust and confidence in the impartiality of Michigan courts, end quote. The report was released in 2012. Tonight we will learn about the improvements needed in Michigan's courts. Please join me in welcoming our distinguished guest, Justice Marilyn Kelly.
Thank you. Well, it's a pleasure to be here. It's been such beautiful weather up here that I don't mind the rain at all. It's fun just to drive up in the sun. A basic premise of our democracy is that we're all equal under the law, right? We enjoy equal protection of the laws. It's in our Constitution. It's written up over the entrance of the United States Supreme Court courthouse. We include it in our oath, in our pledge to the flag. Anybody who grew up in this country knows all about how we're equal under the law. But what happens if you went through this last recession and you lost your job and you never had too much in the bank in the first place and you're facing losing your home? Or what happens if you've had some terrible medical bills this last year that have just wiped out your savings? Or let's say that you have had to face a foreclosure of your home. Is the system fair to you? Are you equal to everybody else who's not in such a predicament if you have to go into a court? It isn't just a question of whether you've got to be up against General Motors or Donald Trump. You could be up against the state government in court. And if you don't have a lot of money, do you really think that you're equal, that you get equal protection? I think in truth we have to admit that we don't. That the concept, the dream of equal protection under the law is an aspirational goal, something we hope for and that we try to accomplish in our government, but that hasn't been attained and probably can't be attained. So what I'd like to talk about tonight a little with you is just how, to what a degree we have been able to attain equal protection under the law for everybody, even for the poor, and what remains to be done. We have some significant failings in our legal system, to be sure. You may remember in school learning about the case of Gideon against Wainwright. Do you remember way back, that was 50 years ago, the United States Supreme Court decided that people have a constitutional right to a government-appointed attorney if a person is indigent, without money, without the availability of money to hire an attorney. That person is entitled, if that person is accused of a crime and in danger of losing his or her liberty and going to prison, is entitled to appointed counsel. That was an incredibly important decision. We did a study. A study was done a few years ago, about 5 years ago, of just how well the system is working, the system of providing counsel to indigents who are criminally charged. And there were some shocking discoveries. This was a nationwide study. The National Legal Aid was the main sponsor of this, but it had the backing of all kinds of people. And the study they came out with a brochure, with a booklet, which was called Race to the Bottom. And it talked about Michigan. It talked about how well Michigan was not doing in providing indigent counsel. And they said, the problem in Michigan is that each county is responsible for funding and providing making sure that counsel is available. And that there's a huge disparity from one county to another. And that the counties that had the biggest need, the most indigent people, had the least money to spend on attorneys. And it was so bad, and there were such differences, that Michigan counties spent per capita, on the average, $707.35 on indigent criminal defense, when nationwide, the spending was $11.36, 38% less in Michigan. In fact, Michigan was 44th out of the 50 states in failing. It was lower than, it spent less than Alabama, it spent less than Georgia. So, as you can see, the difficulty here is not whether we have this right to counsel, it's in providing counsel. It's not worked out well. It's been a black eye for the state of Michigan, and one that we've, ever since this report came out in 2008, we've been grappling with how to fix it and what to do about it. But the problem goes way beyond that. We have never decided in this country that poor people who need legal help and can't afford it for non-criminal matters, civil matters, are entitled to court-appointed counsel. We felt that that was not necessary, and besides, it's just too expensive. But interestingly, other countries that you and I feel maybe we're better than have been doing it. In Western Europe, in Canada, people who are indigent are provided counsel in many civil cases. They're provided counsel in this country in almost no civil cases at all. So you've got to be in a situation where your liberty is imminently challenged before you can cash in on your constitutional right to counsel in this country. Now, you can say, the poor person can go to legal aid, right? We have these nonprofit organizations that hire lawyers for the sole purpose of helping the indigents with their their civil legal problems. Well, we do. And just to give you a feel for how well that's working, consider this. There are about, for every 300 people in Michigan, there's one attorney on the average. There's one legal aid attorney for every 13,000 poor people. Just consider. 13,000 people for every legal aid attorney. So what's happening, of course, is that the legal aid attorneys have to pick and choose whose cases they're going to handle, and they have to reject most of the people who come to them. Or if they handle their cases at all, they aren't able to give them an awful lot of time and attention. So we have a situation in the civil area as well as in the criminal area where people simply aren't getting equal protection of the law, no matter how much it's written in our books and stamped in our stones and proclaimed in our oaths. We have a terrible gap that we have to try to figure out how to handle if we're really going to take any pride in the way our legal system works for people, other than rich people. There's another class of people who have been cut out. You may not think too much about these people if you don't come into contact with them. These are the people who don't speak English, or don't speak English very well. Or at least their English isn't of such a level that if they had to go to court, they would understand all the legal talk that they'd be confronting if they had to defend themselves or if they were trying to bring suit against somebody and recover for example, having been defrauded in some commercial scheme where somebody came and bilked them out of money and they wanted to go to court and try to recover. Judges across the state have tried very hard to locate people who speak the language of these LEP, we call them, people, and make sure that they are told what's going on in the court and that they are able to express themselves through an interpreter, we call them. The trouble is we have very few certified interpreters, people who have passed tests so that they can show proficiency in the language in question. So what really happens so much of the time in so many counties of the state is that the judge will find somebody. Let's say this is a person in court is a Spanish-speaking person. They'll find somebody who speaks Spanish. It might be the person's son, or it might be a cousin. who comes in then and interprets or translates in court between what's going on and the person who's Spanish speaking. The difficulty there is obvious. That person doesn't really know what the job of being an interpreter is. Just assuming that their language level skills in English as well as Spanish are adequate for the job, they really don't know what the job is. And we often have found these people trying to tell the person, the Spanish-speaking person, what his rights are or how he ought to answer a question rather than simply translating what's being said. We have had truly a lot of problems with the LEP people. Another area where we're having a lot of difficulties and deficiencies in our courts has to do with the application of criminal laws to people who they don't fit too well. For example, let's say you've got somebody who's mentally ill and is perpetrating some criminal acts, not because he's malicious or vicious or a criminal, but because he's mentally ill and not able to function properly. The law doesn't easily distinguish between those people. Let's say you've got somebody newly returned from Afghanistan who was subjected to terrible war conditions and is suffering from post-traumatic stress disorder. That person is subject to the same criminal laws if he starts beating up his wife as everybody else would, and yet that person is different. This has been an area where the law has been slow to adjust, slow to recognize that changes have to be made. The law is an institution that doesn't change quickly. In many ways that's important, it's appropriate, but in many other ways it's a disaster. We have deficiencies in the system that have to do not so much with equal protection of the laws as with the public's perception of how the laws are applied and who applies them. And here now I'm getting into the subjects that our task force dealt with. You heard the President tell you about this task force and its recommendations. This was a task force, by the way, that was largely supported by the League of Women Voters. And that was terribly important to us because we were strictly bipartisan or nonpartisan, and we also did not want to be funded by any special interest or political group. And so by being supported by the League of Women Voters, by Wayne State University Law School, by the Kresge Foundation, we were able to draw money for our work that nobody could say had any ties to it. So the League of Women Voters made it possible for us to do this study. And we looked into this whole question of the huge influx of dark money. You've heard about dark money now, I know, because there's been so much written about it recently and so much talk about it. We talked about the influence that money that's being spent in huge quantities, in heretofore unheard of numbers, in judicial elections, the huge impact that's having on the elections, and the fact that this money is unaccountable, that people don't know whose money it is and how much it is. We talked also about the weird situation we have in Michigan where somebody who runs for the Michigan Supreme Court has to get nominated before he or she can appear on the ballot in November by a political convention. So that person has to be political, probably join the Democrats or the Republicans, and cozy up to the party leadership in order to get sanctioned and nominated as a candidate by the party. And then the day after that, the person becomes, the candidate becomes nonpartisan and runs in November on the nonpartisan ballot as not as either a Democrat or a Republican. A bizarre situation that kind of defies credibility. It defies credibility to say this person in November is non-political. And it looks to the public as if the person elected is beholden to a political party and beholden to the platform of a political party, when we all know how important it is that judges be independent and not in anybody's pocket. and not beholden to anybody at all for the decisions they make in court. We have a situation where people are going to the polls in voting or not voting for judges, and voting for judges, and not knowing who they're voting for, not knowing much at all about who they're voting for. I had this happen. It had happened to me a number of times where it became aware to me that people had voted for me, and I was very pleased, of course, that they had. But they did it for the wrong reasons. Someone will come up and say, well, I voted for you because you're a woman. And I'd go, oh, well, that's nice, but that's not supposed to be, you were supposed to have voted for me because I'd be a good judge, right? But of course, they didn't say that. I had one particularly comical situation, and this is the God's truth. The first time I was elected to the Court of Appeals, the day after the election, I knew I'd won. I was going back to my campaign office to wrap things up. It was in one of those tall buildings in Oakland County. I got in the elevator to go up, and there was this youngish man in the elevator, and as the elevator went up, we were chatting, and he found out that I'd just been elected judge. And he said, oh, my son voted for you. And I thought, his son voted for me? Wait a minute, how old is this guy? And then he went on and he said, well, you know, I want my son to be a good citizen, so I took him with me to the polls. He said, well, first I voted, he said, for all the important people. And then I turned the ballot over to my son, and he voted for you. Well, that's maybe an extreme example, but it makes the point that we have a situation where there's been too much voter, if not apathy on one part, ignorance on another, and it can get to be a big problem. We have other problems that our task force looked at too. One of them is that judges in the state are required to not run again once they reach age 70. They can finish their term in office, but at all levels, state judges can't run once they're age 70. Now, that's a provision that was in not the Constitution before this Constitution that we have now that's 50 years old, right? It was the 1903 Constitution that our Constitution of 1963 picked up that provision and included, without too much thought about things like age discrimination. We just didn't talk about that back then. And it's sort of become an outdated type of concept. You can argue pro and con about whether it's a good idea, but times have changed over these many decades, and there are some mechanisms in place today in our state government that would allow people to remove a judge who's become senile or unable to do the work because of age. So, and that didn't exist back when this provision went in the Constitution. Another situation that has been troublesome in Michigan is that frequently the governor appoints judges. You know that. We have an elective system for judges at all levels, but in truth, a good half of those who take the bench in state government first are appointed, not elected at all. And then they run in the next election, but they run as an incumbent, so they have a big advantage. So we have an elective appointed system. The appointment part is utterly without checks and balances. Strange to tell. The governor has carte blanche to appoint whomever he wishes to the bench, so long as a person satisfies basic requirements, like being a member of the bar in good standing, and being over age 18, and being an elector in the state. There's, I think, 5 years you have to have been a member of the bar, and that's just about it. There are no other legal requirements. Now, governors will tell you, to every one of them will tell you, that they've been scrupulously careful and assiduously studious in choosing judges to fill vacancies. And I'm sure they have worked very hard at it. But the fact is, if a judge, or if the governor wanted to have a litmus test for anybody he appointed, particularly, or she, to the Supreme Court, there'd be no way for us to know. Usually the governor asks the state bar evaluation committee to go over candidates and make recommendations on who's fit and who's not among the candidates that the governor is considering. But the truth is, it's never revealed what the evaluations were. So the governor could be appointing people to the Supreme Court who were found unqualified by the state bar, and we would never know, and the state bar can't tell. So it's unusual, isn't it, in our system to have no check or balance on something as important as an appointment like to the Supreme Court. We could build something like that in. Let me tell you a little about some of the improvements to these problems that I've been talking about that have been made in recent years and have, I think, improved our system. Number one, remember I talked about criminal indigent defense and the difficulty we're having with getting counties to be more equal in the amount they pay people to represent indigent criminal defendants. The legislature finally has passed a new law, which just went into effect, which requires the state to take responsibility for what the counties do in this area, and to have a plan whereby there's not the disparity that currently exists from one county to another in the funding of attorneys appointed. It looks as if the situation will be greatly improved as that law is implemented. Of course, as in everything else, the devil's in the details, and we'll see how well it works. But it portends a huge improvement over the situation that was described in this booklet, Race to the Bottom, that I described to you. So it looks as if criminal indigent defense appointments are going to be improved in the state. With respect to civil, we haven't got any changes for legal representation of civil people who are indigents, but some things are being done. Lawyers are donating a good bit of time, pro bono, to help the indigents with problems, and they're to be commended for that. I must say, though, that the court I was on, the Supreme Court, has not seen fit to raise the level of pro bono work that's being asked of lawyers, or the amount of money lawyers are being asked to contribute to nonprofits that do this work if the lawyers are not willing to do pro bono work. But even without that, we do have some firms in the state, like Miller Canfield, and I think Dyke Gossett, some of the biggest, that require their attorneys to do pro bono work, or if they don't, to contribute a certain amount of money to those who will do that work. I started a task force when I was Chief Justice, which I'm very proud of, which set up a website. I want to tell you a little about this website. It's called Michigan Legal Help. And I'll leave some material out on this for you. But if you want to go sometime to michiganlegalhelp.org, you can see what this website has. This is a website for poor people who can't afford an attorney, whose maybe English skills are not very good, and who need help, and who are likely to go into court empty-handed with no help at all. And it's happening. It's happening all over the state. Judges will tell you that they have many, many cases before them where at least one side has no attorney. And it's a desperate situation for people. Michigan Legal Help will help a person in that situation.